This video is for commentary and analysis under fair use. The views expressed are my own, based on publicly available information and my interpretation of it.
Sometimes framing doesn't require a long statement. Sometimes it doesn't even require a complete sentence. Sometimes one word is enough. The prosecutor in the Siders case says Elizabeth Siders may soon face additional serious felony charges. And I want you to notice what your mind just did when you heard that, because I don't know what those charges are. And neither do you. As far as I can determine, the prosecutor hasn't publicly told us what those charges are. But he gave us one word: serious. And that word gives our imaginations somewhere to go. Hi, I'm Stina, and welcome to Motive and Method. I have a Bachelor of Arts in Communication and more than 25 years of professional experience in written and verbal communication. On this channel, we look closely at language, framing, contradictions, and patterns. Because words just don't tell us what happened. They can influence how we understand what happened. And this particular example is especially interesting because there are non-dissemination or gag orders surrounding this case put in place after defense attorneys raised concerns about inflammatory pretrial publicity and its potential effect on a future jury pool. So today, I want to look at what we actually know, what we don't know, and what happens when two words, serious felony, enter the public conversation without the allegations behind those words being disclosed. Before we go any further, I want you to know that I am not an attorney. This is not legal advice or legal analysis. I'm looking at this through the lens of communication and framing. And I'm also not going to tell you why I think the prosecutor chose this particular language, because I don't know. And of course, I cannot know his intention, but I can look at what the language does. And those are two very different things. If you're new to this case, let me give you some background. On June 30th, 2026, law enforcement executed a search warrant at a home in Hamden, Ohio, in Vinton County. 16 children were ultimately removed from the home. 4 adults were arrested: the children's parents, Elizabeth and Gary Siders Jr., and their grandparents, Christina and Gary Siders Sr. Each was charged with 16 counts of second-degree felony child endangering. All 4 pleaded not guilty, and their bonds were initially set at $300,000 each. Gary Siders Sr. later sought a bond modification because of significant medical problems. His bond was eventually modified to a recognizance bond with conditions, including GPS monitoring. Elizabeth Siders has also asked the court to modify her bond. Her defense has pointed to several things in support of that request, including her lack of a prior criminal history, her financial circumstances, her lack of a history of failing to appear in court, and her willingness to submit to GPS monitoring and frequent reporting. The prosecution opposes her release. And in its response, the state reportedly characterized Elizabeth as a flight risk and a potential danger. But then came this. The prosecutor said Elizabeth faces additional serious felony charges that will be considered by the grand jury. And that's where I stopped cold at that, because I want to talk about one word: serious. If you've been following this case with me, you already know that we've talked about framing before. We've talked about words and phrases used publicly to describe this family, these children. They've used the words pure evil, third world, feral. Those are easy examples of framing to recognize because they are emotionally powerful words. But this one is different. This one is quieter, serious. It sounds almost mundane. It sounds like the kind of word you would expect to find in a court document. But let's conduct a little experiment. Listen to this sentence. Elizabeth Siders may face additional felony charges. Okay, now listen again. Elizabeth Siders may face additional serious felony charges. What changed? We still don't know what the charges are. We don't know the alleged conduct underlying those charges either. We don't know the degree of the potential felonies or whether there is any evidence that supports them. We don't even know whether the grand jury will ultimately indict her on them. In terms of concrete information about the alleged conduct, the word serious tells us almost nothing. But emotionally, it tells us quite a lot. But let's remember, this is a woman who is already facing 16 second-degree felony child endangering charges. So, when someone tells you that a person already facing 16 felony charges could soon face additional serious felony charges, what does your brain naturally do? You think, wait a minute, serious compared to what? If these charges are being singled out as serious when the existing allegations are already this serious, what else could there possibly be? And now something fascinating has happened. Nobody had to tell us. We told ourselves. This is one of the things I find so fascinating about framing. Sometimes the most powerful frame isn't the one that tells you exactly what to think. It's the one that gives you just enough information that you finish the story yourself. Just think about what you imagined when you heard additional serious felony charges. Did you start wondering what else investigators might have found? Did you imagine additional conduct? Or did your mind go somewhere darker than the allegations we already know about? Maybe it did. But here's the important part. Whatever you just imagined isn't evidence. It is ours. It is our imagination and our interpretation based on the word serious. Because right now, we don't know what those charges are or what they indicate. And I don't want to speculate about what these additional charges might be. I've seen speculation about what they could be, but I am deliberately not repeating it here. Because if I'm going to make a video about how easily people can fill an informational vacuum with their own assumptions, it would be pretty ridiculous for me to spend the next 5 minutes filling that vacuum for you. So we don't know. And until we do, we don't know is a complete sentence. Now, let's talk about the gag order. And this is where this becomes even more interesting to me. Defense attorneys in this case sought non-dissemination orders after some extraordinarily strong public statements were made about the family and the conditions in the home. One of the concerns raised by the defense was pretrial publicity and its potential effect on the pool of people from whom a future jury could eventually be selected. Now we have a prosecutor responding to Elizabeth Siders' request for a bond modification. And that's important. This isn't a prosecutor standing in front of television cameras giving an interview about the evidence. This is the state making an argument to a judge in a court proceeding. The prosecution has the right and the responsibility to tell the court why it believes Elizabeth's bond should remain where it is. And if the state believes pending additional charges are relevant to that decision, there is a legitimate legal reason for that information to appear in its argument. But here's where communication gets fascinating. A public court filing doesn't necessarily remain a conversation between two lawyers and a judge. Unless the records are all sealed, it enters a public record. Reporters read it. News organizations report it. Headlines are written. People share those headlines. And eventually, the words, additional serious felony charges, are no longer sitting quietly in a court document. They are sitting on someone's phone. And that someone could conceivably become part of a future jury pool. And again, I want to be very precise here. I'm not saying that the prosecutor chose these words for the purpose of getting around a gag order. And I'm not accusing the prosecutor of violating a court order. And I'm not claiming that this particular statement has, in fact, tainted a jury pool. Those would all require conclusions that I don't have the evidence to make. What I'm asking is a communication question. What happens when language written for one audience inevitably reaches another? Because legally, the audience for this argument is the judge. But communicatively, there's another audience, us. And look at the pathway. The prosecutor makes an argument in a court filing. The filing becomes part of the public record. The media reports what's in the filing. The public reads those reports. And some members of that public may eventually be among the people considered for jury service. Nobody needs to hold a press conference. Nobody needs to give an interview. And nobody even necessarily has to do anything improper. The information travels anyway. And that leaves me with a question that I think is much more interesting than trying to guess anyone's motive. If one of the purposes of restricting extrajudicial statements is to protect the fairness of the proceeding and limit potentially prejudicial pretrial publicity, what happens when potentially powerful framing reaches a public through the court record itself? I don't know that there's an easy answer to that, because the alternative can't be that prosecutors and defense attorneys aren't allowed to make their arguments to the court. Of course they are. The judge needs this information. The attorneys need to advocate for their respective positions. And the public has an interest in open court proceedings. That's very important. Those are all legitimate interests. But communication doesn't stop having an effect simply because it occurs inside a legal process. Words still frame. People still interpret them, and audiences still fill in missing information. So, here's where we are. We know Elizabeth Siders is currently facing 16 felony child endangering charges. We know that she has requested a modification of her bond. We know the prosecution opposes that request. And, according to the state's filing, we know the grand jury is expected to consider additional felony allegations that the prosecutor characterizes as serious. What we do not know is what those allegations are. And until we know that, I don't think we should write the missing part of the story ourselves, because there is a larger lesson here that goes far beyond the Siders case, in my opinion. Framing isn't always somebody standing at a podium using outrageous language. Sometimes framing is subtle. Sometimes it is an adjective. Sometimes it's what someone leaves out. And sometimes the most powerful thing a word does is make us supply words that were never actually said. So now, I want to hear from you. When you first heard the phrase additional serious felony charges, what did that language make you think? Do you think that the word serious changes the way the public receives that information? And what do you think about the larger issue here? The fact that information in a public court filing can reach potential jurors even when a gag order limits what attorneys and officials can say publicly about a case. Let me know what you think in the comments, but as always, please keep the conversation respectful. We can disagree here, In fact, some of our best conversations happen when we disagree. But we're going to discuss the facts, the language, and the ideas without attacking each other. If this analysis resonated with you, please give the video a like, subscribe to Motive and Method if you haven't already, and share it with somebody who might enjoy looking at cases through the lens of language and framing. And if you're already subscribed, thank you. You're helping this community grow every single day. If you'd like to support the channel further, we also have channel memberships available, as well as Motive and Method merchandise. You'll find that information below in the description. And most importantly, don't let somebody else's adjective do your thinking for you.